Good afternoon, ladies and gentlemen. My name is Judge Combo. This is a time set for the court's oral decision in the matter of Tani Ortiz versus Benjamin Ortiz. This is CV 2822-860. Before the court begins today, I wanted to say a couple of things to the parties. First, I wanted to let you know that I understand how troubling of a situation you have found yourself in, the stress associated with that. From my perspective, I want to let you know that I appreciated the way that you addressed the court and the way that you addressed each other and the attorneys under these very unique and trying circumstances. I also want to let the parties know that they were extremely well represented today and throughout the entire process with Mr. Lindsay and with counsel as well. Ms. Osman. These are two of the finest lawyers that I have here in front of me, and you should be very proud of the efforts that they made on your behalf. Having said all that, then, this matter had come on regularly for a 3-day court trial that finished up on September 16th of 2024. The petitioner, Tani Ortiz, was present during the trial, represented by counsel Lindsay. That Benjamin Ortiz was present and represented by Ms. Osman. The court has received and reviewed evidence in the form of testimony and exhibits. I've received argument, and upon review of all the files and records, I now enter my memorandum decision on the record, which shall constitute my findings of fact and conclusions law pursuant to the Idaho Rules of Family Law Procedure 801 et seq. Issues about which there were conflicting evidence were resolved by determining the evidence most credible. After having had an opportunity to observe the witness's demeanor while testifying, their opportunity for accurate observation, the consistency or lack of consistency with other credible evidence, and any apparent bias, if any. In terms of an introductory case history, the parties had first met in approximately June of 1998 in church, where Mr. Ortiz, from time to time, sir, I'll probably refer to you as father, please don't take offense to that, was operating as a minister, and Ms. Ortiz, from time to time, I'll probably refer to you as mother as well. Please don't take offense to that. I mean no disrespect. But mother was a congregant. He was 26, she was 18. They dated twice a week for 3 weeks before they got engaged. And then they were married in Spokane 8 months later on or about February 5th of 1999. They have 5 children born of that marriage. Hudson, approximately age 25. Evan, approximately age 23. Avery, now 19. And 2 other children that are the subject of these proceedings, a daughter. The parties had lived together raising a family until February 15th of 2022, at which time mother left the home while father and the 3 younger children were in Orlando at Disneyland, and she never returned. A petition for divorce with minor children was filed by mother the day that she left the family home on February 15th of 2022, asserting that irreconcilable differences had existed between the parties. She requested that father should have sole legal and physical custody of the children, as she was confident that father would allow visitation without a court order. She asked that the marital home in Coeur d'Alene be awarded to father at a value essentially of $1.4 million, and that she be allowed her personal clothes, the 2006 Lexus, and that $750,000 in cash for her share of what she believed the marital value of the home to be. Father had then filed an answer and a counterclaim on March 23rd of 2022. He agreed that he should have sole legal and physical custody of the children, but he sought a divorce on the grounds of adultery and requested that she pay his attorney's fees. He also sought an equitable division of community property and debt, specifically denying that the parties owned any community real property. Mother filed a responsive pleading on March 24th of 2022 with general denials, and a 2-day trial then was scheduled for August 30th of 2022. On August 11th, 2022, Judge Peterson had essentially orally ordered that mother have some parenting time in Texas, where she had been staying with family. and the trial therefore was continued. On October 3rd of 2022, Judge Peterson entered an order appointing Ms. Walls a guardian ad litem. The trial was then reset for January 3rd of 2023. That trial was subsequently vacated by stipulation. On February 17th of 2023, the court entered an order requiring both parties to submit to a psychological and/or mental health evaluation with the same provider. On April 4th, 2023, mother had filed an amended petition for divorce on the grounds of extreme cruelty and requested joint legal and physical custody of the children, with the children residing with mother subject to father's parenting time, 6 weeks in the summer and holidays, and at other times as they could agree. Further, she requested that she be permitted to move out of state with 30 days notice to father. Father then filed an answer to the amended petition and amended counterclaim. On May 23rd of 2023, the father had filed an answer to an amended petition and an amended counterclaim on May 23rd, 2023, denying mother's requested parenting plan. On April 27th of 2023, the court had joined Grace Sandpoint Incorporated, as Judge Peterson was concerned that the argument as to whether the home on Maple Leaf was a community asset or not would affect the corporation, and that they should have an opportunity to have some input. On June 2nd, 2023, Grace answered that the petition failed to state a claim against Grace and that there was a lack of personal jurisdiction over the corporation. They asserted also that the corporation owned the property on Maple Leaf and that it was a nonprofit legal entity separate from either the petitioner and or the respondent. On June 16, 2023, mother then filed a second amended petition alleging that she should be given immediate possession of the home and that within 90 days of the divorce that the home should be listed for sale and subsequently sold. On November 30th of 2023, Grace Sandpoint filed a motion to dismiss, alleging that the parties have not set forth any allegations or legal theories for recovery against Grace Sandpoint Incorporated, nor had a summons and petition been properly served. On December 14th of 2023, the motion to dismiss came on for hearing. Mother had argued that she never thought that Grace Sandpoint was a necessary party to begin with. Father had no objection to the dismissal of Grace. So on December 15th of 2023, Judge Peterson then dismissed Grace Sandpoint Incorporated from the case for failing to state a claim against Grace Sandpoint and the improper service. Trial that had been set for January 31st, 2024 was continued in order for the parties to pursue mediation. Trial then was reset for September 10th of 2024. But on February 7th of 2024, Judge Peterson voluntarily recused himself. There are a number of legal and factual issues that this court needs to decide. Those legal and factual issues include whether either party or both has carried their burden of proving grounds for the divorce, and if so, whether and to what extent that affects the distribution of property and debt as well as attorney's fees. Secondly, whether the proceeds of the sale of Blue Creek, owned by Grace Sandpoint Incorporated, should be considered community property subject to division within the marital community. Thirdly, what division of property and debt is reasonable under Idaho law. Next, whether either party has carried their burden of overcoming the presumption that joint legal and physical custody serves the best interests of the children. What parenting time serves the best interests of the children. What child support is appropriate considering the Idaho child support guidelines. And lastly, whether an award of attorney's fees to either party is appropriate under Idaho law. So let me start first by taking up the issue then as to whether either parent has carried their burden of proving grounds for the divorce as alleged under Idaho Code Section 32-603, and if so, what impact does that have on the award of property and or attorney's fees? As the parties are probably well aware, under Idaho Code Section 32-603, a divorce may be granted for any of the following causes: adultery, extreme cruelty, willful desertion, willful neglect, habitual intemperance, conviction of a felony, permanent insanity, and lastly, irreconcilable differences. Mother had alleged extreme cruelty, which is defined in Idaho Code Section 32-605 as infliction of grievous bodily injury or mental suffering upon the other by one party to the marriage. In that regard, Mother makes several allegations from which she argues, from the totality of those circumstances, that Father has inflicted both grievous bodily injury and mental suffering on Mother. Her allegations can be essentially summarized as follows. She alleges that Father was emotionally and physically and sexually abusive for over 20 years, that he had sodomized her repeatedly, often forced her to have sex, both oral and otherwise, on a near daily basis against her will, that he had restrained her, filmed her without her permission, made her bark like a dog, pretend to being raped, and had her watch pornography. Further, she alleges that he had screened and monitored all of her phone activity, that he had forced her to disclose her location, violating any right of privacy that she had, that he had constantly beat her down with scripture, preaching to her 30 to 90 minutes without a break, and berated her for being sinful and weak. Further, she alleged that she had managed to operate the 35,000 square foot event center at Blue Creek in Montana and the 160-acre property without assistance, and that Father would rant, complain, and disparage her if it weren't done correctly to his standards. She also alleges that she had subsequently been taken to a safe house with the children for about a week in early January of 2018, and that physical violence had gotten to the point where she alleges that in April of 2018, the Father had threatened to beat her effing face in, and that she was so scared she had to lock herself in a bathroom. Lastly, she contends that this was not a loving mutual union, that she was more of a possession, a tool, than a partner. Father challenges each and every one of these allegations, arguing that while they experimented as a couple, the sexual relations were always consensual, that he never threatened her in any regard, nor did he inflict any grievous bodily injury or mental suffering. Rather, he thought that they were in a loving, committed relationship blessed by God. Until he alleges that Mother began to have an affair with Ronald Buck, which ultimately broke up the marriage. Mother acknowledged that she had indeed met Ronald Buck in the year before February of 2022, before she left. She also acknowledged that the day that she filed for divorce on February 15, 2022, and moved out of the home, that she immediately moved into an apartment with Mr. Buck and began to have sexual relationship with him within days, and that they are currently engaged. She denies any extramarital affair prior to her filing of the petition for divorce. The court has some issues in regards to the credibility of the allegations Mother has made in the following respects. First, she had filed her own petition for divorce on the basis of irreconcilable differences, not on any fault grounds. And then she waited for nearly a year from the time Father filed his counterclaim, allegedly as his grounds, before she saw fit to file an amended petition alleging extreme cruelty. Secondly, she had authored an email/letter to Bob Kaczynski and his wife following the safe house incident in early 2018, in which she acknowledged that she had not been coached by Pastor Remington or Ben on what to say, that she was adamant that Ben is not now nor has ever been abusive, that he had accidentally hurt her on a handful of times over 20 years and would have felt terrible if he knew. that he was not a cruel man, but rather a good man. Further, she alleged that all of the allegations had since been dismissed, that the interaction between she and Ben was consensual, that no crime ever was committed, that she was scared and didn't feel loved, and that Bob had only fanned the flames, Mr. Chichinsky, that he had convinced her to be an abused wife, and that she became that for him. That to say that Ben had been into porn for 18 years, she felt was a grossly exaggerated lie, that she had clicked on porn far more than he had, and that Ben had the least amount of sin than all of us. Those statements...
I apologize. I need to interrupt. Ms. Ortiz seems to have dropped. She says that she's waiting for the clerk to connect her. Oh, there we go. She's back. Thank you.
All right. You can certainly fill her in on what the court's record has been up until that point when she came back in. But from my perspective, those statements are inconsistent with the allegations now made. In addition, 2 of her adult children testified at the trial of the matter that father was actually very affectionate towards mother, that he was always hugging her and giving her expressions of love, that he would kiss her often and tell her how beautiful she was and how much he loved her. Both those adult children testified that he had never yelled or was mean to her or took a harsh or demeaning tone, rather that it was mother that would yell at him and that she wasn't kind to him. 1 or more of those children testified that all the years they never heard him quote scripture to her, that father had done the majority of the work at Blue Creek, and that she was on her computer most of the day. 1 of them noted that there seemed to be a shift in mother in approximately 2017 when she reported that she was done parenting, that she had already done 3 kids and was finally going to be selfish. And so she delegated most of the discipline to father, and that she had become more neglectful in the interim. None of the children had ever heard of any of father's yelling, threatening, or raised voice or belittling of mother. From the court's perspective, if it had happened as often as mother said it would, a reasonable person would expect at some point in time for this to have been heard in some fashion by 1 of the children and for them to vouch for it. Mother's explanation that there were always fans on or that this happened late at night after the children were in bed, given that length of time, the court doesn't find credible. The court also asked itself, why did mother try and find the medical records to document her rectal surgery, which she believed to be related to the sodomy, when she acknowledged that she had never even told the doctor about it? Certainly there could have been records produced from insurance as to the payments that were made for the procedure, but the court received no such documents. If mother's allegations were true, father was sexually deviant, constantly demanding sex, anal or otherwise, but the court wonders, isn't that inconsistent with the email that mother sent less than a year before, complaining on June 9th of 2021 that you refuse to give me the affection, sex, and love that I need. The Blue Creek is more important to you than I am. From the court's perspective, that's more consistent with just being marginalized, being taken for granted. Further, mother had admitted that she had often acquiesced most of the time to father's advances in order to get him to let the leash out a little bit more for her, to have more freedoms. So it kind of begs the question in terms of how is father to know that his advances are unwanted? Most importantly, from the court's perspective, the allegations that have been made are totally inconsistent with the letter that she left for him to read when she left on February 15, 2022, what's been referred to as her Dear John letter. She very heartfelt and truthfully explained that she was dying a slow death over the past 5 years. She spoke of being hurt and how hurt she was when she was told that she would never be a Proverb 31 woman. And she thought, why bother? She was not angry or mad. Rather, she still loved him. She recognized in her Dear John letter that he always had the best intentions for her, but that she was still hurting from the counseling with Pastor Remington that the parties had engaged in 2018, wherein she had to reveal sexual things in front of other men, that she was stripped naked metaphorically. She spoke of being rejected emotionally, being stifled and imprisoned, abandoned and unloved, and that she had started to check out in 2021, which is consistent with what the children had referenced as well. She also indicated that there was no loving union anymore, that she was hurting every day, and tragically considered suicide. She begged that he release her, to let her go. What's noticeably absent, though, from the court's perspective is any blame, any allegations of rape, forced sex, strangulation, fear of him, exhaustion at being yelled at, threats of being beaten. From the court's perspective, this letter was brutally honest about what it feels like to not matter in the marriage anymore, and coming to terms with the realization that all the hopes and dreams you had 23 years ago when you got married had been unrealized. She was slowly dying. This was a mournful plea. Divorce was the only way that she found she could save her life. I cannot find grounds for divorce of extreme cruelty given that history, nor more so can I find father's allegations of adultery to be credible either. Adultery is voluntary sexual intercourse of a married person other than with the offender's spouse. Here the only evidence is twofold. One, from Ron Buck's ex-wife, that she felt he was stepping out on her, as she had seen photos on his computer of Tawny and her kids, and that they seemed to be gone the same times as each other were gone. But it's really mere speculation as to whether any sexual intercourse occurred at that point. May very well have been that mother found somebody that actually listened to her soul. The only other evidence is from father, when he reported that following relations with her, he could tell that someone else had been in there. I find that testimony to be offensive, demeaning, not worthy of any consideration whatsoever. From my perspective, the letter that she left said it all. And even if for some reason the court were to find that father had done some of the things that mother had complained of, those were quite remote in time. The parties had to a large extent reconcile, continued to live together until mother found herself drowning in her own invisibility. Those acts, even if I were to find that some of them occurred, would not have been the cause of the divorce. Rather, the cause of divorce was the irreconcilable differences as perfectly described by her in her Dear John letter. So the next issue then the court has to decide is whether the proceeds from the sale of the Blue Creek property in Heron, Montana were community income subject to division in the marital estate, or rather whether they remain the separate property of Grace Sandpoint Incorporated, not subject to adjudication in the divorce. Father had grown up in a family where his father was the pastor of Calvary in Spokane and had controlled 3 other associated churches. Father had received training as well, graduated in Bible college, and worked as a pastor for several years within his father's ministry in Spokane before taking over Calvary of Sandpoint Church as their head pastor in approximately 2008. That church was struggling and was subsequently disbanded by Father, and Father began a new ministry then under the name of Grace Sandpoint Incorporated. and registered it as a 501c3 corporation. The articles of incorporation were filed on August 26, 2009 and confirmed that it was organized as a religious nonprofit corporation, C501c3, with Father being listed as the incorporator/president and several other congregants over the years listed as directors. The articles of incorporation confirmed that they were forming a nonprofit corporation exclusively for religious purposes, including making contributions to other 501c3 corporations. The articles specifically provided that no part of the net earnings of the corporation shall inure to the benefit of or be distributable to its members, trustees, officers, or other private persons, except as to pay reasonable compensation for services rendered. Further, the Articles of Incorporation noted that upon dissolution of the corporation, the assets would be distributed for one or more of the exempt purposes within the meaning of 501c3, or shall be distributed to the federal government, state, or local government for a public purpose. The testimony in the exhibits demonstrated that Father and Mother had never had a parsonage, that they had actually bought and sold their own home, that they had met all of their own expenses except for the church providing health care and expenses for automobiles given the travel required in their job. The evidence also demonstrated that Father and Mother had sought to develop a Bible college in the area wherein Father could teach and support the ministry of God's Word. To that end, in 2013, the church, under Grace Sandpoint Incorporated, purchased property in Heron, Montana called Blue Creek for approximately $750,000 for the purposes of establishing a Bible college and or retreats. The only name listed on the title documents, deeds, were solely Grace Sandpoint Incorporated. While there were some buildings on the property already, it was clearly insufficient for a Bible college and required significant construction and remodeling of several buildings and a lot of work on the land. The Ortiz family pitched in and played a significant part of that remodel with the help of other parishioners and members of Calvary of Spokane as well. They operated the facility as a Bible college/retreat center for several years, but Father was never able to get accredited, and they slowly moved to more of a retreat for ministers and their families. The family had moved there in 2018 after selling the home that they had purchased individually in Coquilala a short time before. They moved on site into a small house that they renovated to add additional bedroom or bedrooms. Nevertheless, the endeavor had become overwhelming. The dream became a reality of no longer really being possible. And the church, against Father's wishes, decided to list the property for sale. It sold for significantly more than what the church had paid of that $750,000 to approximately $3.4 million. A warranty deed was issued to Darren C. Moore, a revocable trust, on January 10th of 2022. And the church, after all the costs and disbursements, received approximately $1.176 million. I find, leading up to the decision to sell, that Mother and Father did have text conversations or email conversations in which it was clear that there was a misunderstanding that both parties had, that it would give them enough money to buy a home, pay back Calvary, and have a retirement. It was apparent that they had forgotten and or didn't realize that the Articles of Incorporation prohibited the net earnings from inuring to the benefit of or distributable to its trustees, members, or officers, except as pay for reasonable compensation for services rendered. Neither Mother nor Father at that point or since has ever requested back pay for the 1 to 2 years that father did not receive any earnings while with that church, nor did they submit any requests for back pay for any of the labor involved in remodeling the building on Blue Creek property that in all likelihood probably increased its value. There was no indication that any such request has ever been made by either party. Rather, it was maintained, the money was maintained in a corporate account. Now, I understand that father had sought to purchase the Maple Leaf home and even had prepared paperwork that was listed solely in his name and mother's name. That was done before father was told by the title company that you can't do that in a 501c3 corporation. So the home was then purchased in the name of Grace Sandpoint, Incorporated. Once mother left and filed for divorce on February 15th of 2022, the board had concerns as to the safety of the money in the church account. Father disagreed, arguing that mother would never take that money. Nevertheless, they agreed that they put the money into a CD to protect it until father could return home from Florida, where he was still actively engaged with 3 children. Somehow, mistakenly, the money was transferred to father's personal account, which, according to mother, then makes a rebuttable presumption that this is community property. The rebuttable presumption of community property can only be overcome by showing with reasonable certainty and particularity that the property acquired is indeed separate. The court finds that while a valid presumption did arise, that it has been overcome with reasonable certainty and particularity. It was as clearly it was an unintended mistake rectified as soon as possible when father returned and the money was returned to the church shortly thereafter. From the court's perspective, it's not a whole lot different than when a bank puts in the wrong accounting number, puts in the wrong account number for routing purposes, and the money is transferred incorrectly to someone who wasn't meant to. Here, again, father has overcome the presumption by reasonable certainty and particularity. This was proceeds from the sale of church property owned solely by the corporation. Their name and their name only was on the deed as title holder. Their name and their name only was listed as the seller and the entity to whom the transfer of funds had to be made to. Nowhere did the Ortiz family have a legal right to the proceeds of the sale unless the court were to find that the corporation was really just the alter ego of father, such that piercing of the corporate veil should occur. In her brief and in closing argument, mother had argued that father had complete control over the finances, that he had often used church accounts as his own personal piggy bank, that he was the only signatory on all the church accounts, that he ruled the corporation with an iron fist, getting rid of anyone who questioned him, that the board had approved of the purchase of a Maple Leaf home and had promised her that the home would be the party's property. There's very little evidence of any of that. I do recognize that mother and father had filled out paperwork to make an offer on the home at Maple Leaf, but that father had subsequently made an offer through the church, which had been accepted and closed upon following his conversation with the title company, which he realized that you can't do that under a 501c3. Mother felt misled, but father had explained the issue of the realtor and the title company. In support of mother's argument, she cites a number of cases: the Nebraska Supreme Court decision in Medlock v. Medlock at 642 Northwest 2nd, 113. The court has also reviewed the holdings in CH versus RH, which is at 846 NYS 2nd, 560, and an unreported decision in Lubell v. Lubell, which is from the Court of Appeals in Tennessee. Those cases and others make clear that the factors to be considered in determining whether the corporation was really just the alter ego of father included a number of factors. One, who provided the seed money for the funding of the church? In the Medlock case, the seed money was provided by mother and father. Here, the funding for the church was the funds given from Calvary Church pursuant to their status as a 501c3 and donations from congregants. There's no evidence at all that the money came from father or mother, as had been the case in the Medlock case. Further, another factor that those cases look at is whether father had used the corporation to pay for personal expenses, as had been the case in Medlock. Here, there's little dispute that father and mother had owned their own home in Coquilala in their own name, that there's no indication that the church had anything to do with the purchase of that home. The church only paid their salary, and in some years, donations were insufficient to even pay a salary. The only personal expenses that the corporation paid was health insurance and expenses for the vehicles, given the amount of travel that both mom and dad had to place on their vehicles. There's no indication that the church paid for meals, restaurants, family vacations, clothing, utilities. Clearly, the parties did not use the corporation money to pay for personal expenses. There's little or no evidence of that. Another factor in the cases that the court reviewed was whether the board really had any say in things. Here, they did. There's no evidence that father had ruled with an iron fist, fired people. Mark Jones had testified that Ben didn't want to sell the Blue Creek property, but the board was concerned that it was taking him away from his ministry. And so the board had approved of the sale despite father's objection to it. There was no fraud, as was found in the Medlock case. Here, they didn't divert corporate funds for their own use except for salaries, which were actually very reasonable, where father was getting paid $4,300 most of the time per month and mother $1,000 a month as a secretary. There's no indication that they exercised any unfettered control. So again, I do not find that father had ruled the corporation with an iron fist, firing anyone who disagreed. I had also mentioned that I had found that he had acceded to the wishes of the board to sell the property to begin with, that he had never used the church or as his personal piggy bank, that he had paid for the house in Coquilala with their own earnings, never sought to have himself be given a really high salary, even when he had gone 1 to 2 years without pay, had never even asked for repayment of that. The other issues that some of those cases look at is whether the parties had acquired community property that would be expected for them to have acquired over the period of their marriage, in this case 23 years. Because as I recall in the Medlock case, the parties had been in a marriage for a significant period of time and never had their own home other than what was provided through the corporation. Here, the parties had purchased their own home in Coquilala, sold it in June of 2018, right before they moved to Blue Creek. They had earned about $120,000 in profit from the sale of that home, which helped pay for other living expenses that they had. Another factor that occurred in Medlock was that the corporation rarely, if ever, held corporate meetings, and that they had used the money to construct a marital home. Here, the Grace Sandpoint Incorporated had regular corporate meetings with votes. Doesn't appear that there was any money used to construct a new marital home. Rather, they used the profits from the sale of the Blue Creek home in order to purchase a parsonage. Another thing that the courts looked at is in Medlock, they found that while they had been organized as a religious nonprofit, that it had been actually financed by its activities as a commercial nonprofit buying and selling of real estate, and that they received very few donations. The court in Medlock noted and concluded that if the church had been financed by donations from third parties intended to support religious activities, that the equities would have been quite different. Here, the only evidence was donations from the congregants and or money from Calvary that helped support, other than that one-time purchase of the parsonage made by the corporation for the use of father and family, as long as he continued to remain their pastor. Father has no ownership interest in, title in the property that he's currently residing in is in the name of Grace Sandpoint Incorporated. If Father leaves the church, he no longer has a right to occupy it or sell it. There is a provision in the resolution reached by the board of directors that the Ortiz family can buy it at a price set by the board. But the articles are quite clear that there cannot be any self-dealing, and from the court's review of all the evidence, I do not find any self-dealing sufficient to have pierced the corporate veil. Here, Grace Sandpoint was formed back on August 26th of 2009. They received a tax-exempt status as a 501c3 nonprofit corporation. It had previously been within the Calvary Chapel networks of churches prior to the marriage and originated as Calvary Chapel of Sandpoint. It had been overseen by Calvary of Spokane. There's no evidence that the party's personal funds were ever commingled with the funds of Grace Sandpoint, other than the heir when the board deposited the proceeds from the sale of Blue Creek in order to protect it from Mother, who, of note, subsequently did take $23,000 from the corporation without their approval, but that the board had corrected the error once it was discovered and returned the money to Grace Sandpoint, Inc. There's no evidence at all that Mother or Father had ownership of any assets of Grace Sandpoint. They've never carried on any personal dealings in the name of the corporation, nor made personal use of corporate funds. Again, Mother was the one who took $25,000 for attorney's fees from the corporate account without authorization. Father requested a bonus and was granted $10,000 bonus to help him pay his attorney's fees. But there's no evidence that they used Grace Sandpoint Incorporated to buy food, clothing, groceries, travel expenses, vacations, car insurance, or otherwise. Again, the Ortizes had bought their own home in Coquilala, which when sold gave them a profit of approximately $120,000 to use from the years 2018 forward. There is not now, nor has there ever been, any unity of interest between the parties and Grace Sandpoint, Inc. On November 11th of 2021, a resolution from the Board of Directors approved of the purchase of a home on Maple Leaf for $1.4 for primary residence of the Ortiz family. They could purchase it for a price agreed to by the board. The parties resided in that residence owned by the church. It was not owned by either party, but rather was property of the church. Father and Mother had no possessory interest except the right to live there while Father was the pastor. Accordingly, Grace Sandpoint Incorporated and its real property at the address on Maple Leaf is not subject to adjudication in this decree. There is an insufficient basis to pierce the corporate veil. The next issue that the court has to address then is the division of community property and debt under Idaho Code Section 32-712. That section governs the character of the property as community or separate, sets forth the standard to be used in the disposition. Unless there are compelling reasons otherwise, 32-712 requires that there shall be a substantially equal division of community property and debt, as the court, from all the facts of the case and conditions of the parties, deems just. In this case, mother is not requesting spousal maintenance or support, nor does she allege that there are compelling reasons exist to divide the community property and debt in some fashion other than a substantially equal division of community property and debt. The parties at the trial of this matter had essentially agreed to the inventory of property and debt and the allocation therein subject to an equalization payment. The court accepts that division agreed to by the parties as follows. So I'm just going to go through what the numbered items of property were, their value, and who it went to. 1 through 3 was property of Grace Sandpoint, not community property. 4, the 1993 Land Cruiser was to go to father at $1,000. 5 was a 2005 Toyota Tundra, also to go to father at $7,500. 6 was the 2006 Lexus, which was to go to mother at a value of $8,000. 7 was father's clothes, valued at $2,000. 8 was mother's clothes, valued at $2,000, both to go to each party. 9 was father's jewelry, to father at $100. 10 was mother's wedding ring at $2,500, to go to father. 11 had been scratched. 12 was the antique bedroom dresser, to mother, as it was separate property. Father needs to allow mother to be able to retrieve that. 13 was the oak bed. That'll go to father at $500. 14 was the Mossberg shotgun, to father at $300. 15 was a shotgun to father, as it was a gift. 16 was the AR-15 to father at $1,500. 17 was the Mosin Nagant gun to father at $300. 18 was a .308 caliber rifle to father to value of $1,500. 19 was the ammo to father to value of $1,500. Kevlar vest to father, number 20, at $600. Number 21 was the Xbox to father to value of $350. 22, 3, and 4 all go to father with no value. Those are the old Samsung, the garden bench, and the espresso machine. 25 is the foyer table. That goes to father at no value. 26 is the foyer rug to father at $500. 27 is the snowblower to father at $750. 28 and 29 are gifts that go to father. 30 is the air fryer, goes to father at $0. 31 is a custom-made table to father at $3,000. 32 is a Russian tea set to father at $700. 33 through 35 are gifts to father, so at $0. 36 is a round marble table. It's a side table to father at $100. 37 is a Catco knives to father at $300. 38 is the woodworking tools to father at $7,000. 40 was Xbox, chair, and games to father at no dollar. The big screen TV to father at no dollar. 42 is the iPad, iPhone to father at no dollar. 43 is the SIG P320 to mother at no dollar. 44 through 48 to father at $0. 49 was the Polar Ice Chest, both to father at $100. 50 through 55 were to father, as it's really Grace property. 56 is the Avery's antique desk, that goes to Avery. 57 and 58 were lined out. 59 is the STCU account, 1811. Each gets 50% of that balance, whatever it may be. 60 is the STCU account 9549. That's to be split in half as well, 50% of the balance. 61 is a gift to Avery. 62 is the African Idols. That would go to father at $0. The debts, both the American Express credit card was zeroed out, as was the Apple credit card. Those will both be father's responsibility. By the court's calculations, then, father ends up with property, this community property worth $16,700. Mother ends up with property that is community property of $10,810. That leaves an equalization payment of $29.45 that would need to be made by father within 60 days. I would also require father to prepay for a storage unit for a 30-day period big enough to fit all the property that mother is being awarded. Father is to put a new battery in a Lexus and fix the tire at his expense and store it, that and mother's other items at his expense for 30 days. Afterwards, if mother fails to retrieve those items, then she must either pay for storage until she's able to retrieve them, or the property will be sold in a commercially reasonable manner, costs of sale being deducted by father. The balance and proof by way of receipts would need to be given to mother, and the proceeds from the sale forwarded to mother as well. If there are any undisclosed debts, they would be assigned to whomever incurred the debt and failed to disclose it. The next issue then that the court has to address is whether father has overcome the presumption that legal and physical custody of the children serves the best interests of the children sufficient to award sole legal and physical custody. Father has requested that the court award him sole legal and physical custody. Mother, in her initial petition, had also requested that the court award father sole legal and physical custody of the 3 children at that point. But over a year later had amended her petition requesting that the court order joint legal and physical custody with the children residing with mother, subject to father's parenting time 6 weeks in the summer and per a holiday schedule, and at other times they may agree. She also requested permission to move out of state with the children with 30 days notice to father. Now, under Idaho law, unless one parent is an habitual perpetrator of domestic violence, it's presumed that an award of joint custody serves the best interests of the children. This presumption can be overcome by a preponderance of the evidence. Here, I do not find that father to be an habitual perpetrator of domestic violence. In the years leading up to the petition for divorce filed by mother, throughout the majority of the lives of a stay-at-home mom, attending to all their needs, physically and emotionally, as father was busy with his ministerial duties. She cooked, cleaned, and was responsible for management of the church property. In Blue Creek, from time to time, the family had moved there in 2018, and at times that had become overwhelming. There was so much work that needed to be done to the facilities to make them appropriate for their intended use, and yet mother still had to cook and clean and prepare for hosting of the retreats. However, in the last 3 to 4 years before the property sold, mother had become far more removed from day-to-day attention and had seemed to delegate their upbringing to Avery and Evan. Avery's now 19. The mother had openly acknowledged that she had already done 3 kids and was going to be more selfish, taking care of her needs first. And as such, she spent considerable time on her computer and let Avery, then oftentimes known as Avery Mommy, take care for their daily needs. The children were homeschooled once the house sold in Coquilala and they moved full-time out to Blue Creek in June of 2018. But the children's learning took a hit, and by the time mother left them on February 15th of 2022, they were far behind their grade level. At the time that they left, it was unannounced. Mother had left a note for father while he was gone to Disneyland, and the children were obviously crushed and distressed, wondering why their mother had left them without even saying goodbye. They felt and still feel abandoned. Court recognizes how traumatic this is for these children. The shutdown, Hans Verde kept wandering around telling himself and anybody else who would listen that mom was still gone grocery shopping. Avery was heartbroken. Father, to his credit, enlisted them in counseling, and it seemed to help them through the loss and grief that they suffered. Mother's relationship with her children after she left home has been spotty at best. She alleges that father had obstructed her parenting time, but what father had done is simply merely insist that one of the adult kids be there during the parenting time, as he was worried that she would take them. because there had been some suggestion in that regard. Again, father had worried about her threats to tape those kids. She remained in the area for several months before leaving for Texas in approximately May of 2022, where she had family. She moved into an apartment with Ron Buck the day she left the household on February 15, 2022. She had gotten temporary order from Judge Peterson allowing parenting time, I believe on 5 occasions, 3 in Coeur d'Alene, 1 or more in Texas. She acknowledges that they were awkward, didn't go all that well. From the children's perspective, they were bothered by the fact that mother had brought her new boyfriend, Ron, along against what they considered to be the court order. Mother hasn't seen the kids since approximately November of 2022. She has sent cards and letters, but refuses to use the phone out of concerns of stalking and father tracking her. Mother's treatment of the adult children, to some extent, has been problematic. Avery had told her that she was engaged. Mother never really congratulated her, just sent her an email/letter indicating that I hope you don't marry a man that treats you as a whore and a slut. She never went to Evan's wedding and has never met her grandson. Mother did see her in court one time and walked right by her. Evan indicated that she had reached out, but that her messages were being ignored. So mother has had little or no relationship with the 3 older children. Current living situation. Mother resides in various unknown Airbnbs, presumably in the Northwest. She refuses to disclose her location or who else lives there due to her belief that father will stalk her. She won't provide a telephone number because she believes that it will expose her to stalking. The stalking issue is not completely uninvited. Father had hired a private investigator and had spent considerable money tracking mother around. Mother has not worked or looked for work since she left. She wants to wait and see what the results of her settlement are. She is now engaged with Ron Buck, a retired police officer, and is scheduled to be married once this is over. Mother does believe that her life is in danger, noting that father had bought a bulletproof vest. Since mother had left the relationship, father has been solely responsible for caring for the children. He had immediately enrolled them in early 2022 in school, and Hans and Luca are now back up to grade level. The children are adopting well under the circumstances. Both mother and father had completed psychological evaluations. In the first one father took, he was found to demonstrate a pattern of deception with narcissistic presentation. But even then, the evaluator found that there was no evidence that he was not a competent parent. Father's second evaluation found no narcissistic traits, but major depressive disorder. He recommended mental health treatment. Despite all of that, that assessor also felt the father was capable of continuing to care for the children. In terms of the children's wishes, which are a factor the court has to consider under 32717, Hans and Luca wish to continue residing with father in Idaho. They do want to see their mom, but they don't want to see her for significant periods of time. They're still confused as to why she left them behind when she left and abandoned them. Their relationship with their mother now has deteriorated, in part because of a lack of meaningful contact, which is attributable to mother's refusal to communicate with the children in a way other than in writing. Over the time, the children have worked on processing their sense of abandonment through counseling and have been adjusting slowly through that process. When the court looks at the legal standards in this matter, the court understands that when the court considers a parenting time, that the court has to consider all those factors that are set forth in Idaho Code Section 32-717, which provides a list of factors. This list is non-exclusive, but is a bare minimum of what the court has to consider. That list has to consider the wishes of the child's parents as to their custody, the wishes of the children as to their custodian, the interaction and interrelationship of the child with his or her parents or siblings, the child's adjustment to her home, school, and community, the character and circumstance of all individuals involved, the need to promote continuity and stability in the life of the child, and any domestic violence as that term is defined in Idaho Code Section 39-6303. The court finds in this matter that father has carried his burden of proof in overcoming the presumption that joint legal and physical custody serves the best interests of these two children. Granting father sole legal custody serves the children's best interests inasmuch as mother refused to communicate with father by phone or otherwise, nor with her children, which presents significant safety issues from the court's perspective. In terms of the physical custody, the court is awarding joint physical custody after considering all the 32-717 factors in their entirety. I have not given any undue influence to any one particular factor, but rather have considered them in the totality. When I look at the character and circumstance of all parties involved, one of the issues that I want to raise from the court's perspective that I hadn't already addressed is the fact that at this point in time, despite the guardian ad litem's recommendation, mother refuses to engage in any reunification counseling because she had previously been victimized in the counseling she had with Pastor Remington and is not going to put her through that same hell. The reality from the court's perspective, though, is that the reunification counseling, while in some sense benefits mom, is really there for the kids. And I'm not sure that mom really sees that. The reunification counseling helps the children, with the assistance of the parent, to work their way through the issues that they have. And so when mother refuses to engage in that type of counseling that is going to do nothing but help her children, that's concerning to the court. When I look at the need to promote continuity and stability in the lives of the children and their adjustment to their home, school, and community, that's an issue that clearly favors the father. These children are in the same house. They're close to the rest of their family, same schedule, same church, same friends. Whereas they have no idea, nor does anyone in this courtroom have any idea as to where mother is or will be, and what are the circumstances that surround that. Mother's request that the children reside with her and that she can move out of state from this court's perspective is not reasonable. They've not seen her in over 2 years. Her request results in them being taken from the only stable home environment that they've known, away from their only caregiver for the past 2 years, father, and family, and takes them away from the same place to somewhere unknown, with someone or some persons unknown. And that type of request from the court's perspective is truthfully tone deaf. Rather, I find custody pursuant to the following parenting plan to be in the best interests of Hans and Luca. Parenting plan should obviously be in accordance with Appendix A. The court thought long and hard about reunification counseling and whether I should force that issue or not. And I've come to the conclusion that I'm not going to force that issue, even though it's recommended, because mother refuses. I have concerns that that's going to do nothing but delay and impede healthy reunification between the children and mother. But that's her choice that she's made. I'm concerned that it's going to result in unresolved issues with the kids, that it's ultimately may lead to mother being further removed from them as being a significant factor in their lives. But if that's mother's wishes, so be it. I am strongly encouraging, but not requiring mother to participate in reunification counseling because the majority of the assistance is going to be in helping those children come to grips with the loss that they suffered. Father should have primary residential custody of the minor children subject to mother's parenting time as agreed between the parties. In the absence of any agreement, mother should have on-duty parenting time with the minor children 1 weekend a month to be agreed upon between the parties, taking into consideration the children's activities, which should not be unreasonably infringed upon. If their parties are unable to agree, then mother's weekend should be the second weekend of the month, beginning November 1st of 2024, as defined by beginning the second Friday of the month until Sunday evening. If there's no school, it would be 8 o'clock until 8. If there is school, then it would be 4 o'clock until 8 o'clock on Sunday. All of mother's parenting time should occur in North Idaho or Spokane, absent agreement otherwise. And the reason that the court keeps using that term is because it's apparent to this court in all situations, especially this one, that I will never know these kids anywhere near like what mom and dad do. And I will never know what's in their best interest and what works for them. So the parties obviously are free to modify the terms that the court is entering today by agreement. Whether a particular day or times of day or weeks work better than another is going to be up to them if they're able to agree. The exchanges should take place at the Hayden Super 1 unless otherwise agreed, and both parties should remain in their respective vehicles. One of the larger issues that the court has had difficulty addressing is the contact between mother and father. And I understand mother's concerns. They're very heartfelt concerns that she feels she's been stalked, that father has done things in the past, and that she's very worried about having any type of communication with him, electronic or otherwise. I understand that, and I get it. But I think there's a workaround. And the workaround from the court's perspective is that all contact between father and mother, unless agreed upon, or in the event of some emergency, should take place through Our Family Wizard. Now, if the parties aren't familiar with Our Family Wizard, it's an app that you place on your phone. It is a co-parenting tool that allows parents to communicate and share child-centered information and communications regarding the child with their co-parent. The parents can upload and manage the children's activities or calendar and co-parenting schedule, track expenses, share medical and school files, and more importantly to the court is that it allows by default for secure messaging where there is no location provided. I would strongly encourage the parties to set up either a time with Janet Meserve. Her number, by the way, is 446-1179, to discuss the matter with her. Obviously, she can't give you any legal advice and will not intend to, but she can walk you through her understanding of the process. But I know that an FBI agent had recently appeared at one of the conferences that the attorneys regularly attend, talking about Our Family Wizard, that it has a lot of security measures to prevent stalking. That's not what it's intended to do necessarily, but the effect of it is it helps reduce or almost eliminate that because there's no location associated with it. And the recommendation that they had was that if mother is concerned, then she would simply sign in on a new email account through Outlook because it's not trackable, and that when she downloads the Our Family Wizard, again, by default, there's no location associated with it. Because the reality is, even though mom and dad are no longer going to be married following the judgment in this matter, they're always going to be mom and dad to these kids. And there are going to be times fairly frequently that they're going to need to have good communication between each other, if that is at all possible. That communication will lessen the anxiety, lessen the stress, lessen the confusion, and problems that the children have. And so it goes without saying that in those cases where I have parents that are able to communicate well with each other, the better off these children do. It's that plain and simple. The conundrum, though, that we face in this case is how to accomplish that when we have a situation where, from mother's perspective, dad has been stalking her. And that's a legitimate concern. I'm hopeful that when the parties look into the Our Family Wizard, that they elect to participate in that. In the event that they do not elect to participate with the Our Family Wizard, then they're going to have to figure out some way to have some communication, whether that be through one of the adult children, a neighbor, a friend, a grandparent. That makes it far more difficult because there could be errors in what's actually being said and then gets respoken to the other side. So that's an issue that the court would love to be able to solve, but I can't. There's no way I can do that without the parents' involvement. All of the parenting time that mother has should occur in North Idaho or Spokane, absent an agreement otherwise. Father should have some idea, generally speaking, as to what city they're in for emergency purposes. It would be up to the children as to whether or not they stay overnight. My suspicion would be they will, but it's not going to happen immediately. They may take some time building into it, becoming more and more comfortable with mother before that happens. The parenting time that I've outlined would essentially be 8 to 8 o'clock each day unless they're in school. And if they're at school, then it's going to be 4 o'clock when they get out of school until 8 o'clock. If the children elect not to stay overnight. Again, the exchanges will take place at the Hayden Super 1 unless otherwise agreed upon. I would like the parties to sign up for Our Family Wizard. It costs $99 per year, which when you think about it is a real bargain. I'd like them to do that within 7 days. I would also add for a term that would require that neither party should speak negatively about the other, nor hold the other up in a light unfavorable in the presence of the children, nor permit anyone else to do so. These children need to know and believe in the best of their parents. They need to be able to go to school every day and hold their heads high and point to their mom or point to their father. That's my parent. And smile and be proud of it. And when one parent or the other seeks to undermine that relationship, the persons that really get hurt are not the mother and or father, it's those kids. Both parties should encourage and help foster a good relationship between the children and their other parent. Both parents are to have the ability to communicate with the minor children during their off-duty parenting time, whether it be by phone, text, email, or video chat. But the contact shall not be abused, nor unnecessarily interfere with the other parent's parenting time, nor shall it be used as a mean to spy Neither parent should share any particulars of the divorce proceeding, including the guardian ad litem's report, with the children, but rather shall insulate them from any of the adult issues. Mothers should also have a 7-day block in June, July, and August, as agreed between the parties. In the absence of an agreement, mother's parenting time would be the second week of each of those months, defined as the second Friday from 4 o'clock until the following Friday at 4 o'clock. Mothers should also have each spring break from release from school until 6 o'clock the evening prior to school. Mothers should also have the first 7 days of the winter break, which is a Christmas break, from release from school until evening at 6 o'clock 7 days later. Any further additions or changes to the parenting time schedule should be addressed first by either agreement of the parties, or in the absence of an agreement, should, but not required, to participate in mediation prior to filing a petition to modify. It's not been my practice to require absolutely mediation prior to a petition to modify, but it's significantly encouraged. Child support. Child support will be calculated pursuant to the Idaho Child Support Guidelines. Father's income is $4,500 a month or $54,000. No evidence was presented as to the fair market value of the free rental home that father is currently residing in. Mother is currently not employed, not looking for work. Court is imputing to mother $15 an hour times 2,080 hours for income of $31,200. Father to get the dependency exemption. Now, in terms of the child support, the parties had already agreed at trial, and I'm adopting that agreement, that no child support actually be ordered, as mother is going to be incurring significant costs in having to travel for visitations, and that cost would equal or exceed the amounts due, and the court accepts that stipulation. The next issue that I have to address is whether either party has met their burden of proof of entitling them to attorney's fees under Idaho Code Section 32-704 and 705. 704 gives the court the ability, after considering the financial resources of both parties and the factors set forth in 705, to order a party to pay a reasonable amount for the cost to the other party for attorney's fees. The factors that the court has to consider under 705 include the financial resources of the spouse seeking maintenance, including the marital property apportioned to said spouse, and the said spouse's ability to meet his or her needs independently, the time necessary to acquire sufficient education and training to enable the spouse seeking maintenance to find employment, the duration of the marriage, the age and the physical and emotional condition of the spouse seeking maintenance. So we're really not talking about maintenance, we're talking about, in this particular case, the cost for attorney's fees, but the ability of the spouse from whom the award of attorney's fees is sought to meet his or her needs while meeting those of the spouse seeking attorney's fees, the tax consequences to each spouse and the fault of either party. The court finds, first, that father has failed to carry his burden of proof to require mother to pay his attorney's fees. Her petition for divorce was not brought frivolously and without foundation, not that that's a required element, but I just wanted to add that. Even though she didn't prevail on the issue as to whether the proceeds of the sale of Blue Creek were the community property, the issue was certainly colorable, given father's own assumption that it would give them enough money to pay off the debt to Calvary, buy a house, and have a retirement. Further, father has not proven that he lacks the ability to pay his own attorney's fees. He's being paid $4,500 a month, has asked for and received a bonus of $10,000 to pay his attorney's fees, which was an advance on his earnings. which should have been community property, but none of that was given to mother. He was also provided with a home by the church rent-free, also receives vehicle expenses as well. There's no indication that he has shared community income with his wife throughout this process, although he did bear the brunt of the children's expenses for the past 2.5 years, with mother contributing, I believe, less than $500. Father has the ability to pay his own attorney's fees, especially when the home that he's living in is rent-free, and that he has the ability to meet his own needs independently. In regards to mother's claim for attorney's fees, I would note again, to the extent that it matters, which from the court's perspective it probably doesn't, that father didn't defend this claim frivolously and without foundation, that he did prevail on the issue of piercing the corporate veil, although he lost on the issue of fault. Here, mother's resources may be limited to some extent from father's. Mother has a high school education, but had never really been employed in an open labor market, as she had married father when she was only 18. That she had been a stay-at-home mom raising 5 children who are now ages 10 through 25. That she had worked as a newspaper carrier early on in their marriage and also received $1,000 a month while working as a secretary for Grace Sandpoint Incorporated. But it's unknown what her duties really were and what transferable skills those duties may have led to from that work. At this point, she has not worked since she left home on February 15th of 2022. But more importantly, from the court's perspective, hasn't even looked for work, as she's, quote, waiting to see what she gets from the settlement. In the meantime, she's paid very little towards the needs of her children. She had already taken $24,000 out of the corporate account without permission and had used that for some living expenses, but also attorney's fees of her own. She had made it clear in her pleadings and in her pretrial compliance that she is not requesting spousal maintenance or spousal support, and in essence has waived that right. But the same factors to determine spousal maintenance and spousal support under 705 are the same factors that the court has to review in determining attorney's fees. From the disposition of community property, mother gets $10,800 and $29.45 cash for an equalization payment. I also recognize that I have to consider her ability to meet her needs independently. Again, she's not looked for work. While she's not looked for work, I did find her likely capable of $15 per hour, but I never really received any indication as to what her needs are. There's no indication as to rent, utilities, gas, water, groceries, healthcare services, or otherwise. Exhibit G was her declaration under penalty of perjury that she filed on October 23rd of 2023. And in that, she listed each category of expense at 0 because she was living with family or friends. But I really got no other credible testimony about or documents as to her reasonable needs. So this court is unable to determine her financial resources, nor do I have any evidence as to what it would take to meet her reasonable needs. I recognize this is a 23-year marriage. I recognize that her ability to earn wages may be less than father's without some type of schooling or additional training. But again, the court was presented with no such evidence. While there may be a disparity in incomes, how can I make that determination when there's been no effort to even look for work? No labor market survey, no explanation about what earnings she's apt to be earning in a given situation. Given her age or work experience, the fact that I received no indication of any disability that would affect her functional ability to work, it makes the court's attempt to award attorney's fees really problematic. Mother had often referred to herself and father as multimillionaires, and that she wanted to live off the proceeds of the Blue Creek sale. Mom and Dad, it's not your money. It's Blue Creek's money, and it will remain their money. So I would have to find, based upon the evidence that's been presented, that Mother has also failed to carry a burden of proof in regards to an award of attorney's fees under 704 and 705. That she failed to carry her burden of proof that she does not have financial resources necessary to pay her own attorney's fees when she's voluntarily unemployed, not even looking for work, hoping to get a settlement. And I would task Ms. Osman with the duty of preparing an appropriate judgment in this regard. And I'm going to open it up to the parties in just one moment for any comments or questions they may have of the court. Before I do that, I wanted to have one last conversation with father and mother. Your marriage is officially ending. Even though you will no longer be husband and wife, you are always going to be mom and dad to those 5 children. And each of you need to do everything you can to build the other up in a light most favorable to the other party in front of your kids. To do otherwise is depriving your children of a healthy future, of a relationship that they can be proud of. That even though my mom and dad are divorced, they're still respectful to each other. They still respect each other's privacy. They don't speak poorly of the other. They communicate well with each other to help be flexible in my needs. That's what needs to occur. Too often I see the opposite. I am over at the Juvenile Justice Center once every 6 weeks for a week. And while I'm over at the Juvenile Justice Center, I can pick out every single child that appears in front of me that likely comes from a high conflict child custody proceeding. And it's easy to see those children act out in class. They have difficulty behaviorally getting along with people. At an early age, sometimes as early as 8 to 9 years old, they turn to drugs and alcohol as a way to address the conflict that they've seen. Rarely do they graduate high school. Exceptionally rarely do they ever go on to college. They have difficulty with relationships with the opposite sex. And part of the worst problem from my perspective is, or worst consequence of this type of conduct is, the children have a tendency to mirror the very conduct that they watch their parents engage in. And so if this turns into a high conflict child custody proceedings where both parents are tearing down each other in front of the children left and right, the kids, when they grow older and have relationships, are going to treat their spouse, their loved one, the same way that they watch their mom and dad. That should terrify any parent, but it's the truth. It's the absolute God's truth. Because it just leads to generation after generation. Then when they have their children, they're going to mirror the very conduct that they saw the two of you engage in, which then causes their children to become victims of high conflict child custody proceedings, and then their children, and their children, and their children. And this goes on generationally. All right. Everybody all right, or do we need a short break? I'm going to ask for questions here in a moment. Mr. Lindsay? Do you have any questions? Go ahead, sir.
I don't have any questions. I thought that was very detailed and informative. If I have any questions, I'm sure they can be answered with the audio.
Okay. Ms. Osman, any questions?
I do, Your Honor. Thank you. Very briefly. In drafting in regards to the child support, just so I am clear on language, I understand the departure. How am I proceeding on out-of-pocket medical?
I would think that because you're coming to a zero on that anyway,
Okay.
given the payments, that you ought to be able to visit with Mr. Lindsay about that and see what
Okay.
suggestion he may have on that issue. I don't really have a good answer for you.
Okay.
There just needs to be language in there that covers all of us in the event a reviewing court looks at this in terms of why are we deviating,
Correct.
and you know
Right.
what the language is that I need
Yes.
to see.
Okay. I will reach out to him. I just want to make sure that
Okay.
I have that accurate. There was, and just to the sensitivity for both parties, there was a prior protective order for the psych evals. It is my assumption that that protective order remains in place.
Do you know, was that one that Judge Peterson had issued as part of this
I don't know
proceeding?
if that was signed, and maybe Mr. Lindsay. I don't
Well,
have the date of that. I'm not, but I don't know if you signed or Judge Peterson
I
signed. It
don't
was simply
remember I did, but so I guess what I'm asking is that something that developed within this case, or was there a
no
separate
within
civil protection order
within this
proceeding?
case. It was just so that the psych evals were not disseminated beyond these proceedings. That they were not shared, so that those psych evals remained within.
Well, I think they should continue to remain within. There's some some
Yes.
stuff in there that I don't think either parent wants out there for anybody else to see either.
Correct.
So I believe it needs to continue to be remained.
Okay, so I just wanted the ability to acknowledge that that
Yeah.
order would still be in place.
Yeah, it would.
We have no objection to that.
Okay, and then my last question, it wasn't addressed, but based on the history of the case, and before I make assumptions, as these children get older, any issue with the children having phones?
I am respectful of mother's concern as to stalking. And mother, let me talk with you real quick on this issue. So we all recognize nowadays that phones are a part of a child's life. When I grew up, phones weren't even part of most adults' life. And so children have a tendency to be on their phones frequently, whether it be social media or otherwise. There are always going to be problems that arise in terms of the amount of usage, who's monitoring the phones to make sure that there's nothing inappropriate that's appearing on those phones, no pornography or otherwise, that the children are being safe. And so I'm not sure that I have an answer into how best to allow that to occur with mothers' concerns as to stalking. I'm open to suggestions, but you're right, that is probably going to be an issue as children get older, if not right now. I think one of the children is 12, I believe.
Correct.
I'll bet her friends anyway, whether she has a phone or not, I'll bet her friends certainly do.
Yes.
And that if
She
she doesn't
has-
already have a phone, then she's going to be
The
lost in the
12-year-old
process.
does have a phone.
So really what needs to be figured out is how can you allow that contact without Tawny worrying that Ben is just using this as a way to know where she is and what she's doing and where she's traveling to and all those kinds of things. So I don't know that I have an answer.
Okay.
Sorry.
Yeah, I think, I mean, right, I'm hoping it's a non-issue, but I'm trying to get in front of
Okay.
places that I could foresee
And
potential
I
conflict.
appreciate that. There'd have to be, yeah, Mr. Lindsay, go ahead.
My only thought is to suggest that the children may have their phones if both parties agree.
Well, that would always be the language if the parties are in agreement and under what terms and conditions the parties may agree to.
If they don't agree, then if she says she would like them to not come with phones, first of all, I believe she'll have great difficulty in getting them in the car without them. But if she prefers they go to lunch without the phones, I would say without agreement they shouldn't have them.
That's probably reasonable.
Okay, understand that. And then my last question, it was addressed at trial. My client did express in some exhibits that he had concerns with one of those psych evals, and just with that protective order, if that was required in regards to that complaint, that would be outside these proceedings. He didn't want to.
Oh, if he had to, as part of the complaint that he's made.
Yes, he didn't want to
divulge
violate that order.
I think I would be checking with Mr. Lindsay to make sure how that's going to be used, if at all.
Okay, understood.
You want to
But
make
he-
sure that because mother has an interest in that same report too, if things are discussed within that report regarding her.
Correct.
So,
Okay, just want to be in compliance with that. And with that, nothing further, Your Honor.
okay. All right, I know this has been a long day for everybody. It's been a long 2.5 years. I'm sorry that, I have to be tactful here. I'm sorry that one of the other judges after 2 years determined that he could no longer hear this case. I took it over. We got the thing heard within 6 months, and I apologize for that delay. Delay is justice not served. I understand that. And so we'll continue to do everything we can to be of help.